Hi, I'm Brenda Woff. I'm a mediator in the Shenandoah Valley of Virginia and West Virginia. I mediate cases throughout the state of Virginia and West Virginia, and I also conduct in-person mediations in my office in Leesburg and my office in Charlestown, West Virginia. Today, I am offering a little video that gives some background information for parties who are thinking about divorce and thinking about their options when they're figuring out how to draw up their parenting plan. This video is geared towards folks who live in West Virginia. So I'd like to spend a few minutes talking about that. This is going to look at what the law is in West Virginia and how the courts decide custody. Typically, I do cases involving collaborative law and mediation, and the parents are the one deciding custody, but they do need to put their parenting plan in the framework of the law that's required in West Virginia. So hopefully this video will help out folks that are trying to consider how to come up with a good parenting plan. A reminder that this is not legal advice, that in this entire series, any video I make is only about Virginia and West Virginia law, and it would be every single state has a unique family law, so you cannot rely on forms or information or formulas or anything from any state other than the state that you're filing in. So in West Virginia, the court doesn't even use the term custody. We create parenting plans. And the parenting plans have two different parts to them. One part is the part about decision-making. And the part about decision-making covers areas that are important in decision-making. We spent a great deal of time talking about medical decisions, educational decisions, and religious. Where will the kids go to the doctor? Who's going to decide, or how will we decide whether the child needs a medical treatment or braces? Should the kids go to public school or private school? Should they change daycare? What church should they go to? Should they avoid some churches? Those are the kinds of decisions that we work out the parenting plan and decide how those are going to be made. Other types of things that are often included in my parenting plans that I work up with parties in mediation is things like how to resolve disagreements, the how to decide what extracurricular activities the kids should be involved in, some kind of framework for communication between the parents. Sometimes we do what the rules will be between the two houses, and also what where the exchanges are going to take place for custody, or whether the kids are going to be able to travel out of the country or not. Those are some of the areas of decision making. In West Virginia, there's a presumption that there will be shared decision making between the parents. What a presumption is, it just means that the court assumes that it's going to be in the best interest of the children for the parents to share in these important decisions. Now, you can, what they say is defeat that presumption and have the court order sole decision-making to one parent, but that's pretty unusual, and that parent needs to be demonstrated usually to be unfit and unlikely to participate in the decision-making. So decision-making is usually shared decision-making in West Virginia. Let's look now on to custodial responsibility. And that's really about, where is the child going to sleep? Who's going to have the responsibility for giving them dinner and breakfast? And how are we going to decide that? Just like there is a presumption of shared decision-making, there's also a presumption of shared custodial responsibility. And under recent legislative changes, if there's a presumption that the sharing is going to be equal between the two parents. A lot of people find that to be surprising. I've heard so many people say, I want sole custody. In West Virginia, there really is no language in the statute that talks about sole custody. It's always about how will the responsibility be allocated between the two parents. If one parent is away in the military or works as a job that takes them away a lot, certainly one parent may have the lion's share of the custodial responsibility, but it still goes into the parenting plan. How is the custodial responsibility going to be allocated between the two parents? And the general rule of law is that both parents are fit. There's, again, it's a presumption. So you can prove they're not, but as you walk into the court assumes that both parents are fit. And the kind of polar star for deciding which would happen with the kids is what's in the best interest of the child. So anytime you're looking at what is the parenting plan going to look like, these are generally two things that you can kind of think are guidance. If you think that one of the parents is unfit or that children are in danger in a parent's custody, you must definitely talk to a lawyer about your options there, because I'm not suggesting that the court would recommend a shared custody situation if it's going to be dangerous for the children. But that's something that the standard is tough, and you would need to talk with a lawyer who can give you specific advice on how to litigate that issue. Now, I've got this in here to remind us about what about the child? Does it matter what the child wants? It does matter what the child wants, but it's important for us to be very careful about how we consider that. Children often feel stuck in the middle in a divorce. And if the parents ask them where they want to live with one or the other, children often feel like they're being asked who they love more or who they want to be with more. And it's tough for them. So as a general rule, when I'm working in mediation, I encourage parents to make the decision about where their kids are going to be raised between the parents. It doesn't mean you can't consider what the child wants if the child tells you. Just like any other thing, your child often articulates what they might want. And as a parent, you decide whether that's in the best interest of the child or not. This would be the same thing. Under the law, children over a certain age can go to court and tell the court what they want. Again, I want to urge you to really consider strongly going down that road, because I think it can be very difficult on the children. So once you do a parenting plan, are you stuck with it forever? No. It's always, in West Virginia, it's always subject to modification. Usually you have to have a change in circumstances. Somebody's job hours changed, school changed, one of the parents moved. Any of those things can lead to a modification. And again, just like the initial agreement, you can have the agreement go to an order, or you can have the judge make the decision. With a modification, you can apply it and ask the judge to make a modification, or the parents might agree to a modification. So that's kind of the issue of child custody in West Virginia in a nutshell. You might still have some questions. And if you do, please go to brendawall.com and schedule a free meeting with me. You can schedule it right now, and I'll be available to be able to answer your questions and help you decide what's best for you. You may also look for my other videos that provide information on dividing property, on what the process is for divorce, and on things like mediation and collaborative law as an option for process. So thanks a lot, and I do wish you the best of luck as you make this difficult decision and figure out the best possible parenting plan for your child.